If you're heading for the bar, knowing how to actually get a document into evidence is, well, everything. It's not just theory, it's a core skill. So today, we're going to break down the rules from the Queensland Evidence Act for proving documents. Think of this as an essential part of your barrister's toolkit.
Okay, let's just jump right in with a classic scenario, one you are absolutely going to face in practice. You've got paperwork from another state, say a certificate of conviction from New South Wales. How do you get a Queensland court to actually accept it as a proven fact? Well, the answer is all about mastering a few key sections of the Act.
So here's our game plan. We're going to start with the basic challenge of proving documents. Then we'll walk through the playbook for court stuff, how to ID people and companies, and those official state documents. And then we'll wrap it all up with the absolute must-knows for your exams. Right. First things first. What's the core problem here? In court, you can't just slap a document on the bar table and say, "This is true." An assertion on its own is worth nothing. The law demands formal proof, and the Evidence Act gives you the precise recipe for getting it right.
Okay, let's crack open the playbook. This first part is just foundational for any litigator. How do you formally prove that a court actually did something? You know, that an order was made, a judgment was handed down, or a conviction was recorded. For this, sections 44 and 53. They're your primary weapons.
So, Section 44 basically gives you this four-piece toolkit. First, you've got the original document itself, the real deal. Then, there's an examined copy, which just means someone has physically compared it to the original and is willing to swear it's a perfect match. Third, a copy with the court's official seal on it. And finally, a certificate from a proper court officer, like a registrar. Your job is to just pick the right tool for the job. Simple as that.
Now, Section 53. This is your absolute go-to for anything that crosses state lines. It takes all those good principles from Section 44 and makes them work for proceedings from a federal court or any other Australian state. This is exactly how you'd prove that New South Wales conviction we talked about at the start. And here we go. This right here, this is a classic bar exam question just waiting to happen. You have to notice the tiny difference in the wording. For domestic proceedings under Section 53, you can prove any particulars relating thereto. But look at Section 69 for overseas stuff. That phrase is gone. It seems small, but it's a huge difference in what you can actually prove in court.
So, and this is so important to get right, using Section 53 proves that a document exists. It proves that a judge made an order. What it does not do is magically make everything written inside that document true. Section 53 gets the document in the door, but it is not a free pass to get around the rule against hearsay. Never forget that.
All right, so you managed to get the certificate into evidence. Great, but hold on, you're not done. Not even close. Now you have to prove that the John Smith named on that certificate is the same John Smith sitting in your proceedings. Let's see how Sections 54 and 55 help us do that.
Before we go any further, though, let's get super clear on our terms. What do we actually mean by conviction? You see, a guilty plea by itself isn't a conviction. It only becomes a conviction when there's a formal order from the court, like a jury's verdict or a judge's finding. It's a technical but crucial point.
Okay, Section 54 basically gives you a recipe to follow. You get an expert, maybe a fingerprint analyst, to swear an affidavit saying, yep, the prints on this conviction match the person in court. But, and this is a big but, you have to pay attention to those deadlines. You've got to serve that affidavit at least 10 business days before the hearing. And if the other side wants to fight it, they need to give you notice at least 3 business days before. You miss those dates, you're in a world of pain. Proving a company's existence under Section 55 is a bit easier. You can use an ASIC certificate or an affidavit. But in criminal cases, there's a real sting in the tail. The prosecution serves their proof, and then the defense has to say if they're going to argue the point. This is to avoid what we call trial by ambush. And you better have a good reason to contest it, because if you make the prosecution jump through hoops just for fun, subsection 7 allows the judge to hit your client with a costs order. Okay, let's move on to our final section of the playbook. This deals with a whole different class of documents. We're talking official government stuff. Think land grants, crown leases, that kind of thing. And you guessed it, the rules here are super specific.
The big idea here is what I call official gatekeepers. As you can see from this table, every type of state document has a specific person or office that has to certify a copy for it to be admissible. You can't just get a copy from anywhere. It has to come from the Registrar of Titles for a land grant or the department's chief executive for a lease, and so on. You've got to go to the right source.
All right, let's boil all of this down. If you remember nothing else from this explainer, remember this stuff. This is what you need locked away, not just for the exam, but for your first day on your feet in court.
Here it is. 1. Know those 4 methods under Section 44 cold. 2. Never ever forget the Section 53 hearsay trap. It proves the fact of an order, not the truth of what's inside it. 3. Master the procedure and the strict deadlines in Section 54 for proving identity. 4. Know the 2 ways to prove a company exists under Section 55 and the serious risk of a cost order. And finally, remember that different government dogs have different gatekeepers.
So we'll leave you with this question to think about. Getting a document admitted into evidence, that's just the first hurdle. The real art, the next and most crucial step, is figuring out how you're going to prove the truth of what's actually written in that document. And that, my friends, is where the real advocacy begins.